Hi there, welcome. I'm Katia Moran. My colleague Laura Cooper and I lead the Youth Justice Legal Centre at Just for Kids Law. Thank you so much for coming. There are 147 of you at the last count, which is a brilliant turnout for what we hope will be a very informative event. We are delighted to be collaborating with the Children's Rights Group at Doughty Street on a series of legal guides on key youth justice topics. And Laura and I particularly wanted to say thank you so much to Keelan Gallagher, QC, and Professor Aoife Nolan for really making it all happen today. The Children's Rights Group brings together barristers from across all of the practice teams to focus on innovative legal advocacy aimed at securing the rights set out in the UN Convention on the Rights of the Child. This aligns very much with the holistic approach to legal representation taken by Just for Kids Law. The Youth Justice Legal Centre was set up in 2015 by Just for Kids Law, and we aim to support criminal lawyers working in legal aid and to fight for better outcomes for children. Together, we're publishing a series of legal guides, and each guide is going to be launched with a webinar similar to this, led by a panel of experts. Which brings me to the guide that we're launching today. And Ray, thank you. It's called Intermediaries for Child Defendants. It's intended to be a practical and useful tool for lawyers representing children. This is actually quite a niche area of practice, so we hope that the guide and today's webinar will make it more accessible for those of you unfamiliar with the detail. We're enormously grateful to Shawneen Lamb and Kate O'Reilly at Doughty Street Chambers, and also to Professor Laura Hoiano for their invaluable contributions to this work. And to tell you a bit more about the issue today, we've brought together a really fantastic panel of speakers. So just briefly, Professor Laura Hoiano, barrister and senior research fellow at Oxford, and really a leading expert in this area of law. Dr. Brendan O'Mahony, forensic psychologist and registered intermediary. Joanne Cecil, youth justice specialist barrister at Garden Court Chambers, who acted in TI, a leading case in the area. And Joel Benathan QC, leading criminal barrister at Doughty Street, who's acted in numerous trials with children and intermediaries. So briefly, the housekeeping. The webinar's an hour and a half. It's being recorded, and that recording will be available on our website. All of your cameras are off and you'll be muted. We're going to do a Q&A at the end. So if you could type any questions you have into the Q&A function, that would be great. If you have a particular speaker you'd like to address a question to, just pop their name in at the beginning of the question. And I will hand over now to our first speaker, Professor Laura Hoiano.
Thank you, Katia. I am very pleased indeed to have been asked to participate in the drafting of the intermediary guidance. This is just the latest very valuable initiative by the Youth Justice Legal Centre and the Just for Kids Law, who for years have kept an unrelenting focus on the needs of accused children in the criminal justice system, a focus which is lost too many times through too many iterations of, for example, the criminal practice directions. I've been asked to introduce myself a bit more. As Katja said, I'm a practicing barrister at Red Lion Chambers, which is a large criminal set. I also lead a double life as an academic at the University of Oxford Faculty of Law, where since 1994, my research has focused on child abuse and vulnerable witnesses and defendants in the criminal justice system. Since 2012, I have written a chapter of Blackstone's criminal practice, chapter D14, on special measures and anonymity orders. And by happy coincidence, today is the 30th anniversary of the publication of Blackstone's, and that edition is published today. So in this very brief presentation, I can only skim the top of the waves. So I would direct you to Blackstone's, to that chapter, as well as to the articles I've written over the years, where I have rehearsed in detail the arguments for special measures for child and other vulnerable defendants. Now, I'm very conscious that most of you working in the youth court are harried practitioners. You're often receiving several briefs in a single day, perhaps with an hour's notice, maybe even not even of that, to prepare them all. What I hope to do here is to give you a framework for some considerations in reading that brief and in meeting your client for the first time. Now, when the concept of intermediaries was introduced in the 1999 Act, I was deeply skeptical because I did not want anyone to come between me and my witness. And that was what was contemplated by the legislation. However, since then, I've become a very enthusiastic advocate of intermediaries because the guidance and practice has developed a very effective way for them to work to assist counsel and the court, including any jury, in their roles as impartial, independent officers of the court. So if we could have the first slide, please. What I'm going to be talking about very briefly is how intermediaries can help child defendants defend themselves. And three threshold questions I've been asked to address. What are the rights of the child defendant? That's a vast question. Should every child defendant be treated as vulnerable? And how can rights-based arguments be constructed in applications for intermediary assessments and intermediary appointments? If I could have the next slide, please. Now, we have actually a wide and robust human rights structure of entitlements for child defendants, which I will describe. The tricky bit is actually realizing them in practice. I'm starting here with the Council of Europe's child-friendly justice guidelines. And if you look at this, every member of the Council of Europe, and the UK has signed up to this, is expected to guarantee to all children justice that is accessible, including the rights to due process, to participate in and to understand the proceedings. Next slide, please. Now, what we have to do is actually look at the structure within the criminal practice rules and criminal practice directions to actually make that guarantee a reality. And starting with the Crim PR1, we all know the overriding objective, which is to deal with a criminal case justly, but it expressly includes recognizing the rights of the defendant, including those under the European Convention of Human Rights, Article 6. And Article 6 guarantees the right to equality of arms with the prosecution, the right to participate fully and effectively in the trial, and the right to testify and to call witnesses under the same conditions as the prosecution's witnesses. I think we often just think of the Article 6 just as, oh, fair trial rights, without actually trying to dissect them and look at them individually and think how they can apply in a particular case. Also is relevant is the UN Convention on the Rights of the Child. Article 40 deals with child defendants and guarantees their right to be treated with dignity and respect, and also to be reintegrated into society. And the UN Convention on the Rights of Persons with Disabilities, Article 13, which concretizes access to justice for people with disabilities, including children. and requires the UK to ensure effective access to justice for people with disabilities on an equal basis, including age-appropriate accommodation. And this is with the goal of facilitating their effective role as direct and indirect participants in the trial, including as witnesses. So going into the next slide, please, and the right to effective participation. And here we see the criminal procedure rules require the court to take every reasonable step to facilitate the defendant's participation. And that includes giving directions for the appropriate questioning of the defendant, especially where an intermediary is involved. And then if you go to Crim PR 3.9 sub 7, that requires a ground rules hearing whenever directions for appropriate treatment and questioning is required. I'm flagging this up because this means that even where there is no intermediary, whether the court decided not to make a direction because the court thought the questioning could be controlled appropriately, or an intermediary was directed but turned out not to be available, you still have to have a ground rules hearing to ensure the defendant's effective participation in the entire trial. And we know that in practice, it's very difficult to obtain ground rules hearings in the youth court and in the magistrates' courts, generally speaking. But that is something that I would encourage advocates to insist upon. Next slide, please. And now I come to the Equal Treatment Bench Book. Now, this is a great source of explanation of the rights in the criminal and civil justice context. It is regularly reviewed by the Judicial College. We get a new iteration about every 16 months or so. And it is part of judicial training. So do not hesitate to invoke it, because whatever court you are appearing before is expected to adhere to the both the directions and the guidance in the Equal Treatment Bench Book. I would mention also it's hyperlinked to resources and useful research studies, which you might find helpful in citing in your application. I want to direct your attention in particular to page 39, which says that accommodating a vulnerable person's needs as required by law requires the court or tribunal to adopt a flexible approach to deal with cases justly. And it also notes that in relation to children and vulnerable adults, the courts and tribunals have safeguarding responsibilities under working together to safeguard children. So the ETBB is an essential tool in applications. This guidance applies to all levels of court, and it is often overlooked. I'm surprised how rarely I see it being cited in any cases which are reported. And I think it should be one of your first tools. We can go to the next slide, please. So that's the human rights structure. But what about reality? Well, first of all, I think it's useful to compare what happens with child defendants to so-called ordinary defendants, typically appearing for the prosecution. Here we see a joint inspection by the inspectors of the CPS and constabulary saying that children and young people are being left to flounder in an imperfect system. And the effects of that can be devastating. And they were not referring to defendants in making that statement. Next slide. So it's important, I think, to basically set a baseline here and thinking about how the experience of prosecution witnesses in court. And in what is still the headline study by Plotnikoff and Wolfson in 2009, Measuring Up, they found that of 182 witnesses they interviewed, 65% said that they had problems of comprehension. And 55% felt that they couldn't say that to the court, even though they had been advised to do so. One young defendant in this study actually described cross-examination as cross-contamination. Now, these problems are attributable to developmental immaturity and the difficulties the adversarial trial system has accommodating their special needs merely because they are children. Now, on a superficial level, many young defendants do not appear to have a problem understanding the court process. They do not ask questions or admit to gaps in their knowledge, and they often agree with what has been put to them in court. But even repeat offenders are often confused about what actually happens in court and at other stages in the legal process. Many, when they're interviewed, did not say that they did not think they were entitled to be heard in court. Many actively disengage from what is going on in court because it's just too much for them to deal with. Many do not understand the decisions of the court before they leave the courtroom, and for those remanded in custody, this is a significant cause of heightened anxiety. Next slide, please. So having looked at the difficulties of ordinary prosecution witnesses who receive typically a great deal of support in giving their evidence, let's look at the unordinary young defendants. Why do these young defendants have so much difficulty? What do they typically look like? Well, disinterest, hostility, and bravado often mask developmental delays, literacy and communication problems, attention deficits, anxiety, depression, and substance abuse. If you look on the slide, research from the Bradley report, which was a parliamentary report, shows that 20 to 30% of offenders have learning difficulties or disabilities. Possibly 60% of young offenders have speech, learning, or communication difficulties. Next slide. And on top of this, they have often severe educational disadvantage. This study by Her Majesty's Inspectorate of Prisons in 2002 showed that of 6,000 boys entering custody, 38% achieved 7-year-old levels in numeracy and 31% in literacy, and 4% had lower numeracy and literacy skills than a 7-year-old. And then layered on top of this, children in the criminal justice system have 3 times the level of mental health disorders as the general population. I would point out also that educational disadvantage is exacerbated if they haven't been attending school regularly or have previously been in custody where they might receive very poor education. So that educational disadvantage is sadly typical of children appearing in the youth court. So how do we, as professional actors in the criminal justice system, respond to this? Next slide, please. Plotnikoff and Wolfson in 2018 did an update on Measuring Up, aptly named Falling Short. And they did a set of interviews with professional actors. And if you look at the question, how satisfied are you that young defendants are enabled to participate as effectively as young prosecution witnesses? You will see that judges well, 58% said that they were, but significantly, 43% said no. Barristers, 70% said no. Crown advocates, on the other hand, said 90% yes. So the people who have the most direct contact with these young people are very concerned about this. I see I've got a 2-minute warning and I've got a long way to go. So next slide. We have an inbuilt inequality between prosecution witnesses and the defendant. Next slide. As I expect you know, all child witnesses under 18 under the 2009 Act and the 99 Act are automatically entitled to be considered eligible for intermediaries, not so defendants. Next slide, please. And the 2009 Act, which was introduced, forced by the Strasbourg court, repeatedly finding that the UK was in breach of Article 6 for young defendants, said there was no deemed eligibility by virtue of age, that the applicant must show impairment beyond the fact of age alone, unlike other child witnesses. And this is, I would say, a statutory acknowledgement of inequality of arms. Next slide, please. If you look at the eligibility for the live link, you see here under 18, you have to show that the ability to participate effectively as a witness is compromised by a level of intellectual ability or social functioning that is lower than one would expect. And therefore, you then have to show that effective participation would be hindered without the access to the live link. There are parallel provisions for the intermediary, which fortunately have never been implemented. Next slide, please. Let's hope that they don't. At the moment, we have a common law gateway, but it's to be pointed out here that it is, as a very important report from Justice in 2019 pointed out, that it's unacceptable that the courts at their discretion determine what provision will be made, especially access to registered intermediaries for defendants. Next slide. And finally, some conclusions to answer those questions. Firstly, the starting position for everyone involved in the criminal justice system should be that all child defendants are vulnerable in the court setting, even the youth court, even if your client has appeared in the youth court more often than you have. And it's not enough to say, oh, we're all very nice people and we'll be sympathetic and we'll manage. Next slide. Secondly, this is really an important point, which we need to remember, and I think we should remind judges of and remind magistrates of, because it's in the Equal Treatment Bench book, that it's important to remember that the extent of communication difficulties can sometimes be hidden. And despite best intentions, advocates do not necessarily have the required expertise either to diagnose difficulty or to adapt their questioning. That's why we need intermediaries. And that's why, dare I say, the bench needs intermediaries as well. Next slide. My third answer is that in all cases, in respect of every child defendant, it's important to sit down and think about how you can draw to the court's attention the Equal Treatment Bench book, the criminal practice directions and rules, and the context of the practical constraints for this particular child about to ensure equality of arms and the right to effective participation in the trial. And finally, Joe Cecil will be talking much more about this, but require the court to explain in a written ruling how these rights, which I have just canvassed in an extremely rapid way, how these rights will be protected for this child if an intermediary application is refused. Thank you very much.
Good afternoon, everyone. My name is Brendan O'Mahony. I'm a forensic psychologist and registered intermediary. I do complete some expert witness reports too. I'm registered as an intermediary with the Ministry of Justice for vulnerable witnesses or vulnerable complainants and witnesses. I also do undertake defendant cases and family court work as an intermediary. I'm not speaking on behalf of any organisation today. These are my views. However, I have spoken to a few of my peers who have shared their extensive experience of working with intermediaries, working as intermediaries with child defendants. I want to acknowledge that, and I know some of those are present today as part of the webinar. I also want to mention that I am a specialist member of the Parole Board, and the only reason I'm mentioning that is to illustrate that I too experienced the challenge of actually adapting communication for vulnerable people when I'm on my feet too, so to speak. It's a quasi-judicial setting, but even with my expertise in assessing communication and adapting communication, I do appreciate the cognitive load and the demands when you're actually doing it live. And before I move on to my next slide, I just want to acknowledge, following on from Laura's talk, that today's child defendant might be tomorrow's complainant and vice versa. They're not different people, they might be the same people. The next slide, please. The scale of the problem is, at least, we've had this slide from Laura, so I don't need to dwell on it, but at least 60% of young people in the UK who are accessing youth justice services present with speech, language and communication difficulties, which are largely unrecognised. And the point I want to make on this, that was Professor Karen Bryan's research and colleagues in 2015. The point I want to emphasise here is how successful, it's a question, how successful is the youth justice system in identifying these individuals when they're coming before the courts? Next, please. So intermediaries, who are we? Our typical backgrounds, or professional backgrounds, are speech and language therapists, psychologists, occupational therapists, social work backgrounds, mental health nursing, special educational needs, and I apologise to any colleagues who I've missed out any of their professions there as well. The important thing is when you're getting an intermediary, it's not just getting an intermediary, it's getting the right intermediary with the right skill set who's going to actually meet the needs that you have. We're not expert witnesses. The important point I want to emphasise today is our expertise, and that's expertise in assessing communication needs and finding creative solutions. On the left, you'll see a whiteboard, some emojis, some clocks. We assess things like the concept of time and distance, which are abstract concepts. We use all sorts of communication aids, and that is our specialism. Next slide, please. There's 3 points that I've been asked to focus on today, and they are in front of you now on the slides. Firstly, how intermediaries and lawyers can work together to secure an intermediary appointment. Secondly, the points intermediaries can make to support appointment for child defendants. And thirdly, getting the most out of a ground rules hearing. So I'm going to obviously deal with those one at a time. The next slide, please. Oh, I see my order's gone slightly awry there. Not to worry. Okay, so how intermediaries and lawyers can work together to secure an intermediary appointment. Firstly, the emphasis on impartiality of the intermediary role. I just want to emphasise that. I know Laura mentioned it. Our role is to assist the courts, the prosecution and defence. So regardless of who actually asks us in, invites us in, our duty is to the courts, and Laura's made that very, very clear. We ask you to identify the need for an intermediary assessment as early as possible in the proceedings. Last-minute referrals are fraught with difficulties. Not least is it really hard to find one of us to actually do the role, but we need time to establish rapport. We need time to conduct our assessments, to assimilate the findings, to produce a report. There's lots of work we do behind the scenes that perhaps the court doesn't even ever become aware of in terms of our preparation work. It's not necessary for us to have sight of an expert witness report in order to use our expertise and specialist skills to assess communication need. Now, I do work as an expert witness at times, and often When I speak to an instructing solicitor, they'll say to me, oh, we might get an intermediary at some point. And I say, well, if you've got that concern now, maybe you want to get them in place simultaneously. Don't wait for my report, get a communication specialist assessment as well. It's a different item to the expert witness report. So think of both limbs simultaneously. How often do you actually consider obtaining an intermediary assessment when you haven't identified the need for an expert witness report? So if fitness isn't an issue, do you consider an intermediary? For instance, do you know that the young person's had a teaching assistant at school? Do you know that there's a history of truancy there? And are you asking the questions, why is that? And Laura's already alluded to it, that it might be a speech and language communication difficulty, which is why a young person might be absent from school. It might be because they don't understand what's going on, they have attentional deficits, etc. It's helpful for us to have access to school reports, to speak to professionals who know the young person, the youth workers, the youth offending team, teachers, etc. Another reason why we need time. There's the issue of consent that I want to talk about, both to approach these other people, the other professionals, but also we can't work as an intermediary with a young person if they don't consent to our presence. And I have had assessments before where I've been invited in by a solicitor and the vulnerable person did not consent to my assessment, so I had to leave. Make a record of the difficulties that you experience when you're communicating with the young person. Share these difficulties with the intermediary. My advice is have this on the top, one of the top things on your agenda, communication needs, and look out for them from the outset. Ensure you always request our dates to avoid and that we're invited to the ground rules hearing. And you might not always welcome every single one of our recommendations. For instance, the child should give evidence via live link. Our role is purely about what's best for communication. You might be considering other issues. Next slide, please. Okay, points intermediaries can make to support the appointment for child defendants. Ours is a very holistic view on communication needs. We consider speech-language communication. We're looking at attention span, the impact of trauma on someone's communication, their mental health issues, physical health, head injury histories, emotional regulation difficulties, dissociation, triggers to dissociation, fatigue, history of epilepsy. The list is endless what we're looking at, and how does any of that or all of that impact on communication? Importantly, the child may present very well. We've heard this from Laura's talk already. This does not mean that they have no communication needs. So we'll be assessing receptive skills as well as expressive language. We'll be checking out, are the words they're actually using, that they're talking to you and using, are they actually understanding those words? Are they echoing words that you use or that we use, just adding to them to mask that they don't understand? We're highly sensitive to looking out for those issues. We look beyond the bravado, as Laura was saying. We look beyond the head nods and the agreements, the acquiescence, the negative presentation, if that's present. What is it masking? We look at self-esteem issues. We know that some young people will feel silly in front of us being assessed. They don't want another assessment. They feel silly in front of the court, having to acknowledge that they don't understand, and they feel very sorry in front of peers, particularly co-defendants, if they're the ones who's got the intermediary. We look at the environmental factors that can inhibit effective listening and communication, the impact of a co-defendant's presence on communication, noise, distraction, rustles of papers, people walking in and out of the room. We complete our comprehensive communication assessment of this individual, its functional communication need for this appearance at the court on this occasion. And our findings and recommendations may actually differ to some extent to the generic findings of the expert witness. And again, I reiterate, we are experts in communication. An expert witness might say to you that with an intermediary's presence, this person can participate in a trial. We may offer a different opinion. And I, again, just reiterate our expertise. We provide a court report with evidence-based bespoke recommendations of adaptations and communication aids required for this individual. And we recognise that additional communication issues may arise at courts, which the intermediary has the expertise to identify at the time live and to offer solutions at that time. I just want to point out our attention is focused entirely on the young person's communication needs. We don't have other distractions that advocates might have in terms of working memory difficulties, what someone's just replied with, how that fits into the strategy. We're entirely focused on communication. The next slide, please. So getting the most out of the ground rules hearings, the thing that I really want to emphasize here is get us up there engaging. Try not to marginalize us. I'm not going to read through all of these boxes because of time pressures, but we get frustrated if we're invited to attend the ground rules hearing, but we're marginalized from the process. If we're observing from the sidelines, as the advocate does their best to communicate our role and recommendations. So we need to be up there. We're not witnesses. It should be an inquisitorial approach. We need to evidence what the recommendations we're making. If we're arguing for a 10-minute break every 30 minutes, we need to say why. That's our expertise. I'm going to move on to the next slide now, please. Before I go into this summary slide, I just want to say a few other bits here. Today, I have done this intentionally, I've used different styles, colors, and text in this presentation to illustrate that too much information presented too quickly can cause difficulties. You'll see it's much clearer if I speak slower, if I use sequence numbers 1, 2, 3, as on this slide, to make my points, and if I don't have too much information within each of those bullet points. That speaks for itself. And it's an experiential thing that I'm doing today. I'm putting it on here. Now, too many details presented too quickly does not allow time for us to process the information effectively. That's a point that I just really want to emphasize today. This is magnified for people with speech, language, and communication needs. Vulnerable people may be practiced and well practiced at masking their interaction, their communication. They might be practiced at making a best guess at what you are trying to convey. So they might think they know that word, and if they don't, they might guess the answer and be communicating with you in that respect. They may very much worry about saying that they don't understand it. As I've said already, they may feel, silly, don't want to look silly in front of you. And one of the final points before I go on to that summary is they might not actually know that they misunderstand something. Now, this is a critical point, because if you say to them, do you understand? And they actually think they do understand, then they'll answer yes. Now, what about if they don't actually understand, but they think they do? And that is something that as intermediaries, we're going to be checking out, and we can give advice on how to manage that. With that said, my summary points are these. Consider communication needs from the first time you meet the young person. Document your concerns with examples. Acknowledge the expertise that intermediaries bring, and I don't use that word lightly, that they bring to the process of completing an individualized communication assessment and making bespoke recommendations for this individual at this particular court at this time. Include intermediaries in the important discussions. Make sure we are not sidelined at the ground rules hearing. And my final slide, please, is resources that I want you to point you in the direction of. I want to point you in the direction of the Intermediaries for Justice charity pages, the web page there, the link is there. There's a lot of very helpful resources on there, and out of charity, they also accept some requests. You can place requests with them if you're struggling to find an intermediary, and they're not obliged to find you one, but they can try and help you in your search. The Advocates Gateway lists toolkits, not just about child defendants, but there's a toolkit for working with young people with autism, or people with learning disabilities, or people with ADHD, or people with acquired brain injuries. There's lots of toolkits on there that are really, really valuable. And the final one that I want to point out is Adverse Childhood Experiences and Trauma-Informed Practice. There's a 50-minute training session available online. It's free. You get a certificate at the end of it. It introduces you to the impact of adverse childhood experiences on young people, trauma-informed practice when you're engaging with them, and it does touch on communication issues. Thank you very much for listening, and I look forward to the panel discussion at the end.
I think it's my go next, so unless I'm told otherwise, I will plunge straight in. I'm very flattered and pleased to be asked, and may I commend the guide to anyone who's not yet read it. It's a great piece of work. I'm sure it'll be very useful. I should say I'm actually in the library at the Central Criminal Court, so if there's the occasional tannoy call, please excuse me, and if I have to eject someone from the library when I'm halfway through speaking, I'll fit it into what I have to say. 3 things I've been asked to deal with. I have 15 minutes, so let's get straight to them if we may. Firstly, intermediaries in Crown Courts, judicial and legal responses. This breaks into 2 parts. There's what is the theory and what is the practice. And the theory, as so often in life, the theory is all good. And I start with the easy reference point, which Laura referred to, of the Equal Treatment Bench Book. The Equal Treatment Bench Book sets out for judges and magistrates the source of the sort of considerations we have to have in mind, the legal sources. The Equality Act 2010, the European Convention, the UN Convention on the Rights of Children, etc. It sets out statistics. 2015 study showed that up to 60% of young people in the youth justice system have speech, language, and communication needs. In 2017, the Youth Justice Board reported that of all admissions to youth custody, 61% of young people were not engaged in education, 33% had mental health concerns, 32% as having learning disability or difficulty concerns. And it sets out a battery of methods and possibilities and options and laws that can be used to assist with these children defendants. That's what's written in the books or electronically on the Equal Treatment Bench Book. What happens in real time? Well, what tends to happen, I'm afraid, is what happens so often in the criminal justice system. There can be an idea how the criminal justice system treats battered women. The theory is fine. The law of what we used to call provocation has been adjusted specifically. But when the courts are, sorry, I'm in a Zoom, but don't mind me, Gareth. When the courts are confronted with a real woman who's actually accused of killing someone, suddenly we forget it. Suddenly it's 6 of one, it's half a dozen of the other. It's the same with most or many young offenders. The theory is fine, but as soon as you actually get one of these kids, and often they are kids who are streetwise, they've learned tactics to hide their limitations, they have their own pride, they can sometimes be funny as a way of distracting from things they don't understand, from difficulties in their life. So they don't present as doe-eyed children of great innocence who magistrates or some judges or some barristers would find easy to treat more gently. I mean, Laura made the point, sympathy and compassion on the part of judges and counsel are not enough. Well, they're not enough, but frankly, there'd be a good start in a lot of the cases I've had to try to deal with. Let me give an example. A case of an appellant, who I'll use the initials CH. She had a receptive vocabulary similar to a child aged 7. He was 13 at the time of the offence, a murder he was accused of. He had the understanding of sentences of an 8-year-old, the working memory capacity similar to a child in infant school, limited in his ability to challenge. If he didn't understand something, he wouldn't challenge it, partly because often he would not realize he hadn't challenged it. So we launched the appeal. We do what we have to do these days, which is say to the trial lawyers, who were not we, what happened at trial, why were these difficulties not accommodated, why were the rules not followed, and the answer we get back, one of the answers said, let me find it, he was streetwise. Him and his mum were content with the arrangements, but I don't suppose his mum knows what the guidelines hearings are meant to amount to. I don't suppose he is familiar with the criminal procedure rules. The Court of Appeal looked at a transcript of his evidence and said, in effect, he did fine. Well, not that fine, because he got found guilty, was our obvious riposte. The subtext is, and I think there's no point us dodging away from this, that magistrates, judges, lawyers, members of the public, jurors will actually look at the defendant, and they often will be someone who's been in trouble. And maybe that's not unrelated to them not being able to prosper in education, not being able to prosper more conventionally because of the limitations, because of the intellectual problems and difficulties they have. And they will look at them and they will say, and forgive me speaking bluntly, amongst so educated and liberal an event, they will say, this defendant's a nasty little thug. So there may be guidelines, but he knows what time of day it is. He knows what the scene is. He knew well enough to go and get the knife that day, and they will pay lip service to the various protections that are meant to be in place. What you do about that, I know Jo is speaking next, and I will leave her to make suggestions which I'll listen to with great interest. All I would say is you need advocates at trial level who are bloody minded and insist on the rules being followed, even if it inconveniences the court, which it nearly always does. And as an appellate lawyer, we actually need the Court of Appeal to start overturning one or two convictions for serious matters, and then finally judges might realize that the rules are there and the rules need to be followed. The two other matters I've been asked to deal with, techniques for working with intermediaries and evidence in chief and cross-examining with an intermediary. I'll do the first one shortly, if I may, because I think Brendan has actually engaged with a lot of this. I think the key propositions we all have to have in mind is to remember the judge is in charge, not the intermediary. And that means this: if we want the intermediary's representations on behalf of our lay clients typically to carry weight, to be enacted, we have to communicate with the intermediary before the hearing, before the day of the hearing, and if needs be, during the hearing. And we have to articulate and argue for what they are saying. Again, to deal with an appeal, I think the same appeal. In effect, we had an example where a co-defending barrister cross-examining this, I think by then 14-year-old, the intermediary says he can't understand that question, and the barrister said in front of the jury, in front of everyone, he doesn't need you protecting him. At which point, really it needs the defense lawyer for the child defendant to get up and say, well, actually, yes, he does. Anyway, so communication, listen to your intermediary and take their part if their advice, if their expertise is not being given paid proper accord. The last of my three topics, evidence in chief and cross-examining with an intermediary. Well, again, we tend to find we bump our heads here against the legal professions who think they have been questioning people, no doubt brilliantly, for their entire career, and they're not going to change now. We really are asking, and I aim this particularly at my fellow barristers, we really are asking people who may not be quite so flexible, having learnt their trade, we're asking to change the habits of a lifetime. But the sort of things that are required with witnesses, defendants in particular, but with any child witness and with intermediaries involved as well, are the judges being more prepared to case manage on a base which would have been unthinkable maybe 10, certainly 20 years ago. Limiting the length of cross-examination, intervening to stop repetition in cross-examination. There are, of course, a whole list which a lot of the advocates, I'm sure, watching today and those training to be advocates will already know. But there's a whole list. Cross-examination techniques have to avoid complex vocabulary and syntax, avoid leading multi-part questions. These can confuse adult witnesses, never mind children. There is, of course, the guidance, which I hope everyone knows about, by now, the Inns of Court College of Advocacy have produced training which judges are meant to have watched and judges are meant to commend to any advocates before them. When asking questions of a witness in these circumstances, you should introduce the topic, give a headline to the area of the case you're going to ask about. That also, I would imagine, makes the intermediary's life that much easier. Use names instead of using he or she. Single topic questions, no compound questions, no leading questions. Now, cross-examining on that basis would be completely alien to an awful lot of us who have been, cross-examining on and off for heaven knows, many years, many decades even. But a leading question to a vulnerable child witness, whether they be a defendant, defense witness, prosecution witness, runs the risk that what they are doing is not actually giving you an answer which takes the case any further forward. They are simply acknowledging that you are a grown-up, an authority figure, and you are telling them what the position is, and they're simply going along with this. We all do that to an extent, but the sort of children who would require an intermediary do it far more than that. So no tag questions, a proposition put with the word T at the end. Again, complicated structures. Isn't it a fact that? Is it right that? That sort of thing. Do you remember? Again, that would seem a very basic question in cross-examination, but if you make it a test not of what happened, but whether they have a memory of what happened, you are already making life harder than it needs to be for the child. Figures of speech, I'm going to jog your memory. The present tense we're told to avoid. Are you at school? Well, the child knows they're not at school. They're in a court. They're giving evidence. Leading question should be avoided, and a challenge that the witness is lying or confused. There's actually very good support, very good authority for these packages of tools. The Advocates Toolkit video has Lord Judge, the Lord Chief of 5 or 10 years ago, really underlining this. We have to change how we deal with children witnesses, and if that change is made, then I hope the task of intermediaries becomes significantly easier, because the intermediary should actually be encouraging people on a road they are already embarked upon. They should not be having to object to numerous questions. They should be having to clarify or intervene to ask that a question is rephrased. And if someone already knows what the problem is, and if someone has the learning and the skill set to actually understand what they're meant to be doing in a case like this, then I would hope very much that the intermediary finds their job much easier, and those of us who are acting for example, defendants who have an intermediary find our jobs much easier as well. The rules have totally changed. For example, one last example, no longer would it be appropriate with many child witnesses to show them other evidence which may contradict their account. A judge will agree that that could be done separately with the jury, for example, in a Crown Court case, to avoid distressing, confusing, or asking the child to comment. If I have to draw all this together, I would say there's a great deal of learning out there. There is really no excuse for people who are acting in these sort of cases not to have partaken of that training, not to have read their way into the literature. Judges have an overriding responsibility to do justice in these particular cases. There really is no excuse for a judge these days not to be able to do that. If one is in front of a judge who isn't doing it, they need to be told. If we're considering a case after a conviction or a sentence where the judge didn't do it, the Court of Appeal needs to be told that the judge hasn't done it. And may I say, just in closing, that the guide, if anyone has not yet had a look at the guide that has been produced by Just for Kids and the Justice for Children Legal Centre, and by some of my colleagues at Doughty Street as well. It really is very much worth a read. It is a tremendous help, and I commend it to you. Thanks very much.
Hi, so I've similarly been asked just to introduce myself, but having flicked through the list of participants, many of you are ultimately very familiar already, so I'll keep this relatively brief. I'm a barrister, as you can see, at Garden Court Chambers, with a particular interest in children and the criminal justice system, and so undertake a variety of first instance trial work, appellate work, and indeed cases that go to the High Court on judicial review. I've had the pleasure of working both with Joel and with Just for Kids and the Youth Justice Legal Centre on a number of cases now that engage principles involving the use of intermediaries, including the one that Joel just alluded to in the case of CH, which I think we would both still agree represents to both of us a grave miscarriage of justice. Unfortunately, Court of Appeal didn't agree. And so my involvement with intermediaries also has gone slightly further in the sense that I've also been involved in training intermediaries from a criminal barrister's perspective. And I'm also one of the lead facilitators for the Advocacy and the Vulnerable course. My primary reason for being here today is really to talk about the case of TI versus Bromley Youth Court. And we're going to use that as a case study to go through the whole process from start to finish and look at how to make such an application for an intermediary, what happens when one is refused, as is all too common, and where do you go from there. Thank you, Ray. So I've been asked today to discuss three things. The first is how to prevent bad first instance decisions. Second is the options and effective ways of challenging those decisions, and then finally looking at the case of TI. And so the way that I'm going to do that is to contextualise it within the case of TI. Thanks, Ray. So dealing perhaps with the basics first of all, and all of you will be familiar with this. How do you prevent bad first instance decisions? It basically comes down to preparation, and more preparation. And the first aspect, and it's already been dealt with by all the speakers actually, Laura, Brendan and Joel, is early identification of issues. Those issues need to be identified as soon as possible in the process, because there are a number of steps that you will then need to undertake. And as Brendan alluded to earlier, that may involve the instruction of psychological or psychiatric experts, in addition to then an assessment by an intermediary. For my part, generally speaking, I've found that you are more successful in these applications if you have both sets of evidence before the court. As with any application, the more evidence that you have of need, the greater chance there is of success. Any other evidence that you can collate, again, Laura's gone through some of that. Brendan has set out a very helpful flowchart as to the information that they would require: school reports, ECHPs, anything that would assist. And as you'll see when we turn to the case of TI, it went broader than that, in that the assistance was also sought from the Youth Offending Service, his particular case manager, who was also able to speak about the communication difficulties in that particular case. As you can see here, Joel's mainly concentrated on the Crown Court, and so I've really concentrated on the Youth Court or the Magistrates Court. And as you can see here, first thing to do, flag it up on that PET form. So the PET form, for those that who are not familiar with the language, is essentially the preparation for trial form. So it's the equivalent of what we would have in the Crown Court in terms of a PTPH form, a plea and trial management hearing form. And now there is a specific section, certainly, and to dealing with vulnerable defendants as well as vulnerable witnesses, which was at least one of the good things that came out of the case that involved CH, albeit lots of other things were a little bit more depressing. As I said, and then finally put the intermediary assessment as well before the court. The second aspect to any application, and I know everybody is really busy and everybody is under pressure, but try insofar as you can to make a full and proper application. Generally speaking, you're only really going to get one shot at it, preferably in writing, because it means that the court then has to engage with the arguments, and you can also later then evidence the fact that you have raised these arguments and issues, and how has the court dealt with those. use the relevant statutory framework. I'm not setting them out in any great detail here because in reality they are set out in the cases of Dean Thomas and TI. So those are the ones I would recommend as effectively first starter reading, and that will take you to all of the other relevant authorities, some of which are hugely important. For example, AS in Great Yarmouth is not on here, but that's really important because it distills the ultimate point, which is that the only factor in play for a court ultimately is whether that child or defendant has the ability to have that fair trial. So it's an individualised assessment. But Dean Thomas and TI do a whole sweeping gauntlet of all of the relevant authorities, and so provide quite a useful starting point, and certainly for you to springboard from. And ultimately, children are different. It shouldn't need to be said. But a lot of the authorities, all bar TI and one other, refer to adult defendants. And of course, we're not dealing with adults, so we have very specific needs that also relate to children. Again, it is depressing. There's a reluctance on the part of perhaps the court and the appellate courts to really grapple with that issue properly. And you'll see as we move through the slides that there is some discussion of that later when it comes to some critique, some criticism that I received as a consequence of the judgment in TI. So what happens when you get a negative decision? And we've seen a lot of negative decisions over the last few years. Firstly, as a consequence of changes in the criminal practice directions, and then secondly, as a consequence of some of the authorities such as Rashid, which appeared on its face, and again, we're going to go to this in more detail shortly, to advocate for a very narrow application of the test for an intermediary. So what do? The first aspect is to consider, can you renew that application? Do you have anything additional that you can put before the court that would warrant a renewed application? If no, the second aspect is then what do you do from there? You either go ahead with the trial, absent an intermediary and hopefully with different adaptations put into place, or do you consider whether or not your case is one that actually ought to be subject to an appeal of some type, or whether that be effectively judicial review? If it is, then you're going to need to decide very quickly whether you need to apply to adjourn your trial date pending that determination, and speed is going to potentially be of the essence. That was certainly the case in TI, as we'll go and we'll go through what was happening in terms of procedure there, and where there was a pending trial that was within weeks. And in fact, the judicial review and an application for interim relief, and that's something you may also need to consider, is whether you need to then go to the High Court if the application to adjourn the trial is refused, was made effectively a day before the trial was due to take place. Alternatively, do you let the trial go ahead and then do you appeal to the Crown Court? There are going to be different considerations depending upon the facts of your particular case, and each of those avenues is going to need to be considered very, very carefully indeed. So moving to TI, and hopefully drawing on some of those earlier strands. So TI was a 14-year-old boy at the time of the alleged offence. He was charged with theft from a person, essentially on a bike, cycling by with a group of other young people, and snatching a telephone, and then also a breach of criminal behaviour order because he was said to be associating and on a bike with with a boy that was not allowed to be with under the order. On the face of it, the evidence was very strong. This is not an attractive case when it comes to the merits of the actual substantive matter. There was identification and an identification procedure by the complainant who had her phone taken. There was identification by officers who were present in the general vicinity and had been called to the incident. And there was, and that evidence was also offered by the police officers in relation to the identification of the individual that he was not supposed to be with. So that's the starting point, not the most attractive of cases. Second, equally not the most serious, but nonetheless not attractive, evidentially. We then moved to the interview. In interview, he gave a prepared statement that denied his involvement. It denied that he was present on the specific road in the area. It denied that he was with the other young person that the criminal behaviour order prohibited, and it stated and set out his case that he was in the general vicinity but was on a different road at the relevant time, that the identification was mistaken. And I should add, this is perhaps an example of even when you make the best of applications for intermediaries and the like, they get refused. He was an individual who had 9 convictions for some 14 offences over the last intervening 2-year period. This was all dating back to 2019, including robbery, theft, common assault, public order matters and other issues, and numerous breaches of his criminal behaviour order. With the exception of one, all of those had been guilty pleas. There was one case, one matter in which he had a trial. That trial resulted in a conviction. There was no intermediary for the trial. TI himself had a number of difficulties and very limited cognitive functioning. He had a history of neglect. As you can see here, he was the subject of a child protection plan. And the EHCP had been prepared for him, and he had not attended school properly since the age of 11. What became starkly apparent was that in addition to the cognitive difficulties that he had, and we'll move to those in a moment, he had particular difficulties engaging with adults, whether that of professionals or other individuals, and certainly those in positions of authority. When it came to the assessments with both the psychologist and the intermediary, the answers that he would provide were typically single word answers. It was very difficult to engage. He looked away, looked down, did not answer questions. And when he did, as I say, single word, maybe 2 to 3 words to a sentence. So a psychological report had been commissioned. Had actually been commissioned for a different set of offences to which he subsequently pleaded guilty, but was temporally relevant. It was within a month or so. That report assessed him as having a borderline learning disability, an IQ of 70. Those cognitive deficits crossed the entire remit and in terms of his abilities, so his verbal comprehension, his working memory, and indeed his suggestibility. The earlier ones fell in the bottom 2nd percentile of the population, essentially meaning that 98% of children of his age would do better than he did, and significantly so. So we are talking about somebody with significant cognitive functioning deficits. I should say, a little bit like CH, not that dissimilar. He was highly suggestible. There was an aspect of trying to get things over and done with. He felt that there was little point in engaging, because even when he'd actually tried to engage, he would still be told that he was doing things wrong, that he would get into trouble. He just wanted it over and done with, deferred to those on authority, and would effectively acquiesce. The psychologist concluded that essentially, absent an intermediary, he would not be fit to not be able to effectively participate. There was an intermediary that was needed to not only in terms of the provision of his evidence, but also to ensure that he stayed engaged throughout that trial process, understanding both his role within that trial process, that he did have something important to a role that was important to play, but also that he could understand what was taking place, particularly going through the trial. And of course, the pinch point, as it's often referred to within the authorities, of the time when it would come to the prospect of him giving evidence if he so chose to do so. Thanks, Ria. Similar findings were made by the intermediary, who also raised issues regarding suggestibility, his comprehension. And what was very helpful was that it really broke down the ability that he possessed in terms of understanding sentences, and that was at the age of around a 9-year-old. Again, similar problems in engagement, spoke mainly in 2 or 3 word answers. Further support was then sought as well from the Youth Offending Service, who had quite a high level of engagement with him in the preceding time. And the youth offending team worker there confirmed that he found it very difficult to concentrate. She needed to make sessions very short. You'll often see that sort of recommendation within intermediary reports in terms of ability to concentrate in 20-minute spans, 20-minute conferences, that type of thing. And that she needed to use a variety of tools and visual aids. That he struggled with complex words or sentences, that she was having to adapt her language and giving him really multiple choice style questions. He had spoken to her about the previous trial experience. He found that very stressful. Of course, that's one aspect that one needs to consider, because in relation to children, we're also looking at welfare of the child. He did not understand why they were saying that he was lying, didn't want to answer any questions, and was very likely, in her view, to just simply shut down. Whether that was because he didn't understand the words being used as it's set out within the quote from the report there, or because of the approach that was taken. And effectively, if he couldn't really understand and comprehend the situation, he would withdraw. And those are all typical things that we see with many, many young people, and Laura's already spoken about at length. And so, I think I'm just getting a little timing suggestion. Yep, on a 2-minute alert. So we've got very little time to whiz through this. But in short, the decision and the reasons are actually really important to look at, because many of the reasons that were provided in refusing the application are those that you will see all the time. So the youth court is a specialist jurisdiction. It's a tribunal that's used to dealing with young people. We can do this. And counsel and their lawyers, their solicitors, they're used to dealing with young people. They can do it too. That's the first one. The second one, that was roundly rejected by the court, which held that actually, no, you need an individualized approach. Does this child need help? Does this particular child need assistance? Secondly, that Rashid, as I said earlier, set a high bar for the appointment of an intermediary. It would be a rare case for an intermediary to be appointed. Again, it was confirmed that that was a misreading and misapplication of the case of Rashid. Of course, intermediaries will be relatively rare in the generality of cases, but that does not apply to the individualized assessment of an individual. You'll see the third reason was where the court can provide directions to ensure that the recommendations of the intermediary are adopted. Again, very little thought given to that. The reality was there was nothing beyond the generalized, no tagged questions approach. Again, court rejected that approach. The administrative court on appeal rejected that approach. And then finally, the fourth one rather, the court will provide for a ground rules hearing. Didn't really add much in terms of what would actually be done on that particular day, because of course ground rules hearings are supposed to be mandatory. They should be happening in any and every case, in any event. If we move on. Next reason that was given was that he had appeared in court 4 times previously. He'd been convicted after a trial. He'd given evidence in that trial. He'd plainly been able to give evidence in that trial. It's the underlying tone of it, albeit it's not actually expressly said, but reliance was placed on the fact that no appeal had been made against that conviction. So the presumption is it was a safe trial. It was a safe conviction. It was a fair trial. The administrative court on the judicial review rejected that as well. It's found that was of very little relevance indeed, because effectively there's just no information as to what exactly happened on that previous occasion. The next reason that the court gave in refusing was the reliance on a prepared statement in interview, and stated that that prepared statement was sufficient to demonstrate that he understood the issues and that he was able to give insufficient instructions. Of course, those of you who practice in the police station, and we were able to put this evidence before the High Court when it came to the judicial review, will understand that often a prepared statement is given precisely for the reason that that young person is very likely to be unable to effectively participate in that police interview. And albeit they may be able to give basic instructions, there's very little beyond that. And then finally, and perhaps the most offensive of reasons, that this was a lawyers only case. And this really goes back to the fact that the case, as I said, is not an attractive one. It was a relatively overwhelming one, on paper at least, but that there was no alibi evidence to be called. It was essentially a case of challenging that identification and that correctness of the identification. And for those lawyers among us, will all be familiar with Turnbull and those principles. And as a consequence, there's a very limited part to be played by the defendant if he is to participate at all. And then goes on to say, somewhat astoundingly, and certainly this was picked up by the High Court judge, And if he chooses to give evidence, then it will simply state that he wasn't there, nothing more than that. But if he chooses not to give evidence, that no adverse inference from that will be drawn. And of course, at that point, a judge is simply not in a position to be able to make that determination, because they will need to hear from the Crown, the CPS as well. Over the next couple of slides, and I'm just going to really just summarise them very briefly as Ray moves forward. It really just sets out the procedural history, which really goes to show, don't give up, because the application seeking interim relief to stop the trial going ahead, to stay that trial, was refused initially, with the High Court judge saying that the district judge was a very experienced tribunal, and as a consequence, the chances of any success were slim to nil. Nonetheless, that was renewed. That interim relief was gained, permission was subsequently granted, and as you will see, when hopefully you all read the case of TI, it not only was permission granted, but the challenge was upheld. And Ray, if we just go to the final slides, and the final slides really just outline the judgment of the court, and I've gone through each of those aspects already in relation to the district judge's reasoning. So in short, my advice, if you are faced with this, is to get all of your ducks in a line, get the wheels in motion in relation to the experts. Look at, if you need to challenge it by way of judicial review, move quickly, because you may have that trial date coming up, and don't give up. And I know that I'm afraid is a whistle-stop tour, and I'm sure we will probably have some questions, and I'm more than happy to answer any questions in due course. Thank you.
Thanks so much, Jo, and to all of the speakers. We are going to move to the Q&A now. We're slightly behind time, so we're going to go over for an extra 10 minutes to 5:10. Obviously, some of you may not be able to stay for that time, but you are welcome to if you can. So I think maybe I'll ask all the speakers just to turn their cameras back on. And I'm going to start with the first question is really for Joel. Jo might also want to come in on it, and it comes from a mental health worker, and it says, even when I give background information on communication or learning difficulty, in my experience, many lawyers don't apply for intermediaries. How can someone like myself advance that an intermediary might be needed?
What I would think is, I mean, I've not experienced people not taking an interest in it before. What I think you can do is, firstly, you must be entitled to say to the young person themselves and their parents that you think it will be a good idea and they should discuss this with their lawyers. I think you can say that in a supportive way, which isn't criticizing the lawyers unnecessarily and creating frictions with them. Secondly, I think if you are in doubt that this is being listened to, you need to say, I am troubled, I'm not sure he or she could express themselves properly, I really think they need help, and I'm worried if they have a trial without that help, it might not be a fair or a safe conviction at the end. Now, that doesn't guarantee anything, but it might have the lawyer concerned, and they should be concerned for their client's interest, but it might have them concerned about their own position. And if you are doing something with some, not necessarily formality, but with some clear, persistent theme like that, I would do it in writing. That's probably an email or a WhatsApp these days, but I would have some record of it, because, you know, most lawyers are doing their best for their clients with a degree of skill, but none of us are immune from thinking, if this goes wrong and there's proof I've ignored something I shouldn't have ignored, I could be in trouble. So I'd get something simple in writing and tell them you've done it. Thank you. Anything to add on to that, Jo?
I would just echo what Joel said and make sure that you are asking or telling the legal representative quite explicitly and raising the issue explicitly. So have you actually considered the instruction of an intermediary here? Have you considered whether it's or a psychological assessment, or whatever it may be that you think is important, raise it explicitly so that you get a yes or a no answer. And as Joel says, put those concerns of yours on the record, and then they're there.
Thank you. Next question is for Brendan. Does it ever happen that there might be more than one ground rules hearing in a case?
Yes, it does indeed happen. On a defendant case, for example, there might be a ground rules hearing right at the beginning of the trial. And when the court is actually considering, does the intermediary need to be there throughout the whole trial, or just for all testimony only? So there might be a ground rules hearing at that stage. And there might be a further ground rules hearing if the defendant elects to give oral testimony, then a fuller and more detailed ground rules hearing later on in the trial. And I'm just going to add a little bit to that. At one of those points, there's going to be some talk about the intermediary reviewing questions, hopefully, and a timetable set out for when the lawyers might share their questions, their proposed questions, with the intermediary, so that the intermediary can review those questions and give some feedback if there's any changes needed. So that will take place hopefully sooner rather than later.
Thank you. Next question is for Laura and comes from a law student in Bristol. Is there more to be done within law schools to distribute the really important information that we've heard today? Oh, you're just still muted, Laura, sorry.
I'm glad to have a question from Bristol Law School because I used to teach there. And when I did on my evidence course, vulnerable witnesses featured prominently. Also in the advocacy training sessions I used to run there. However, I think that it is very common for evidence courses in law schools and law faculties to be concerned more with doctrine rather than these kinds of practice questions. I would point out, however, that the Criminal Bar Association has been zealous in training advocates. Now, I've been involved in that kind of training and across the circuits ever since 1999. And there had been a plan by the Ministry of Justice to require all of us at the publicly funded bar to have that training for vulnerable witness questioning. But that does not extend to when and how to apply for special measures. And that the compulsory requirement has fallen away, as so many Ministry of Justice projects do. So I think all we can do is continue at the level of the bar to try to keep hammering these messages home. And it's enormously helpful to have the Youth Justice Legal Center, for example, providing the kind of guidance which is being published today. I wish we could do more in law faculties, but I fear that it often means practical experience on the part of the faculty member, which might not be present. Thank you.
Thanks so much. And this one, I think maybe I'll put to a couple of people, starting with Joe. Is it possible to explain the difference between a registered intermediary and a non-registered intermediary?
Yep. So the Ministry of Justice have a witness intermediary scheme called WIS, effectively, and for complainants or witnesses who are giving evidence in criminal trials. As part of that scheme, they utilise what are called registered intermediaries. Registered intermediaries have to undertake a specific training course and are registered with the Ministry of Justice. That's really what that relates to. They are only used for complainants or witnesses, generally speaking. When it comes to defendants, we don't really have such things as registered intermediaries, albeit we have, without going into lots of detail, we have taken cases before in the past in relation to the disparity between the two. And in theory, at least, everybody should be entitled to a registered intermediary. But the reality is that it's a descriptor that applies to the Ministry of Justice's scheme, which is not open as a general rule to defendants. And so non-registered or unregistered intermediaries are used for defendants, albeit they are often one and the same people, which is probably worth flagging up. Now, I may have got something wrong with that, but that certainly was my understanding, and Brendan may have more to say on that particular issue.
Yeah,
they are often the individuals who act as registered intermediaries often act as intermediaries for defendants too.
Yeah, I wanted to bring Brendan in here, given that he is the registered intermediary. I think it's sort of quite interesting to hear people's views from the different positions. So we've heard from Joe. Now, Brendan, could you elaborate?
Yes, of course. I can add to that. I am one and the same person, a registered intermediary if I work with a complainant or a witness, and an intermediary if I work with defendants or if I work in the family court. So I'm one and the same person. What I would add to that is that there have been some concerns that I've heard or myths put around that because someone is not currently an MOJ registered intermediary who's undertaken the MOJ training, that they might not be as good as or as employable as an intermediary as someone who is on the MOJ register. And I think it's only fair to say that there are companies that are mentioned in your new guidelines, they are mentioned in there, who have their own training schemes, they have their own ethics, they have their own complaint systems and whatever. And an argument's often put forward that the MOJ intermediaries are the only ones that are preferable. My advice would be to look at the other companies, ask them by all means what their training is, what their codes of conduct are, etc., and satisfy yourselves that they absolutely are providing all of those issues as well to your satisfaction.
Thank you. Next question is for Joel. How do we begin to change the attitude of advocates and the judiciary towards child defendants, towards them just being seen as streetwise?
We organise, we propagandise, we conduct seminars like this, we issue handy guides like the one we are advertising, if that doesn't sound too commercial. I do think it's a matter of learning, and it's a matter of people not being shy to take this on, to challenge it. I mean, I was in a trial here at the Bailey, coincidentally, of a child defendant and up for murder, and the junior counsel for him, the junior barrister in his team, it was her responsibility to watch the clock. We'd said we'd have a break every hour, and when everyone carried over an hour, she got up and said, "It's now an hour." Now, in a case like that, it's very easy to get rolled over, and the judge will say, "Well, we're only 20 minutes off the lunch break. Maybe, he seems to be paying attention jolly well." And she would get up and say, "Nope, it's an hour." I mean, an hour and 5 minutes we would probably allow. But you have to be bloody minded. You have to be prepared to be a nuisance. And that really is a matter of education. I would also say, secondly, we do need the senior judiciary to both pronounce in theory, which they're not bad at. I normally never lose an appeal for a child defendant without them saying something should have been done better, but actually to overturn a conviction or two in some of these serious cases. I don't want our audience to think I have a particularly cynical view of the judiciary or practitioners, but knowing you won't just get a mild comment, but a conviction a judge has presided over will be overturned with the waste of a month's worth of trial money, whatever it is, isn't a bad thing. But even at the highest level, I mean, this is not the time for anecdotes, but not long ago, again in this building here, I had a very young defendant convicted of terrorism offences, and the sentencing judge said, "Well, you may be very young, but you are a clever young woman, a clever, very radical young woman." To which we said, in the Court of Appeal, almost in these words, "Yes, she is clever. Yes, she is radical, but she's also a young person who's been groomed online, as it happens, by a jihadi in Syria in that particular case." So the two aren't incompatible. You can be streetwise and oppressed. You can be extreme and have been radicalized. We need to hammer this home. In that particular case, they cut the sentence significantly, which was a help and does send out a message. So I'm afraid the short answer is the learning is there, but we need to know it and keep banging on about it and keep pushing it in front of judges and lawyers and prosecutors and other defense lawyers. No substitute for that, I'm afraid.
Thank you so much. This next question I'd like to put to Brendan and also for Laura to come in on it. The question is, I have just heard about a recent Crown Court trial where the judge did not allow an intermediary for the defendant, but instead asked the young person's YOS worker to sit with them throughout the trial. Is that acceptable or usual practice?
Who do you want to start with on that one? The lawyer side of it, or me as a practitioner?
I think we could start with you, Brendan.
I would say on that, what I'm going to emphasise there is my duty as an intermediary is an impartial role. I'm not there as a supporter in any way. My expertise is in communication, both the assessment and in facilitating the skills. And I'm going to leave it there. So in my view, it should be the intermediary who is impartial, who knows the workings of the system, who knows what they can and can't do, what they can and can't say. And I'm going to actually buy a little bit of time here back about a question you asked me earlier about ground rules hearing. There is another occasion of ground rules hearing might happen, and it's later on in the trial when an intermediary might see something where a ground rule hasn't been, where the original agreed ground rules hearing comments haven't been adhered to. The intermediary might go back into the court and say to the judge, look, this is happening, or I found a new communication issue. Would the youth offender service person know that they can do that? Do they know those rules of engagement of what they can and can't do? And I would argue we do.
Thanks so much. And Laura, sorry, you're just on mute.
There we go. I don't know if you can see, but I've just grabbed my criminal practice directions 2020 here. There has been a recent amendment to the CPDs, which have said that the court has recommended that the court can direct that a supporter attend the with the defendant and sit in the dock alongside the dock officers. There is no information whatsoever about who will pay this person to do this. And in terms of whether it's the youth offending service and the propriety of that, I think it would depend very much on the involvement of that particular officer and the service with that defendant. The role of this person is extremely unclear as well, and also whether there should be any qualifications for that person in terms of being able to explain what could be a very complex criminal trial in terms of what's happening. I am extremely skeptical that it's possible for anyone to fulfill this role who hasn't had extensive experience with the criminal justice system. And it may be that a YOS officer is the best person to do this, but there is, in my view, no way that such a person can replace an intermediary if the intermediary is needed for the entire trial to actually explain the language of the participants in the trial to prevent the child from just being a spectator.
Thanks so much. Okay, we've got time for just one last question, which I'll ask both Joe and Laura to come in on, and then we will wrap it up. Have the speakers found that child's rights arguments successful Have the speakers found child's rights arguments successful in support of appointing an intermediary at first instance hearings?
I'm not sure who you want to go first.
Sorry, I was going to ask you, Jo, to start.
No, that's absolutely fine. No, yes and no is the short answer. The courts are not overly receptive to arguments that, in my experience, that invoke principles that we would like to rely upon, particularly on the international level. And when you come to the appellate level and you're appealing, or you're in the High Court or the Court of Appeal. Certainly that was certainly the case in CH. And in fact, that's one of the things I was going to discuss if we'd had a little bit more time in relation to the case of TI, because you will see within TI that there is criticism of reliance on some of the international aspects and some other child sort of rights friendly arguments that were being made. And so again, echoing what Joel was saying, it's very disheartening actually, because I don't think the courts are dealing with it properly or correctly. But the most successful way is really to, from my experience, and again you see it in TI to some degree, is really using the domestic authorities that we have and really grounding it in those as much as you can. It's really frustrating. I wish I could say something that was slightly more positive. That doesn't mean that I think we should stop making these arguments. I really don't. And I can perhaps give an example which is related but different from the US, where international law arguments were seen as just forbidden. Appalling, would never come into any argument, into any case at all. Started to make a chink in one of the cases that abolished the death penalty for juveniles. And now it's cited much more regularly. And so we do see it within our courts too. Our courts are much more receptive than the US is to international law arguments and child rights arguments. But in criminal justice in particular, there's a real reluctance often on the part of the Court of Appeal to really grapple with those issues. That's certainly my view. I don't know if Joel agrees with that. And it's frustrating.
Thanks. And I just wanted Laura to come in on that question.
Yes, briefly. I think we need to remember that a lot of the changes which have been introduced, especially in the 2009 Act, but also the practice directions, have been driven by judgments against the UK in Strasbourg. So I don't think we need, I think it's important that we not neglect those cases like T&V and SC in the UK. We need to sometimes go back and refresh our memories about the very strong language that was used, because I think they can be helpfully inserted into submissions. But what I was trying to do was to show how the international rights of the child are expressed, find expression in the Equal Treatment Bench Book, which does expressly cite those international instruments. And I think that is one route in to submissions before at first instance that relies on international law. But do use that route in, because these courts are bound by the bench book.
Okay, thank you so much. I really just wanted to say, firstly, thank you to the speakers. Really, it's been an absolute privilege to hear from you all. Thank you to everyone for coming. We hope you enjoyed it and that you used the guide. As I said at the beginning, this is just one in a series of legal guides that we're publishing. Here's a picture of all the other ones. The next one is on child criminal exploitation. Again, we'll be having a webinar on the 3rd of December, and we hope that lots of you will join us. Thanks so much.